Welcome to EUPrivacyForAll Session46 on GDPR, Tasks of the Supervisory Authority, Article 52. In negotiations regarding Article 52, European Parliament suggested additional inputs, such as certifying controllers and processors as being a core mission for supervisory authorities. It also added that each supervisory authority shall, together with the EDPB, promote the awareness for controllers and processors on risks. This includes keeping a register of sanctions and breaches, and provide micro, small and medium-sized enterprise controllers and processors on request with general information regarding their responsibilities and obligations. On EU Council side, several items were added to the long list of tasks to be carried out by the DPAs, such as promoting public awareness and understanding of the risks, rules, safeguards and rights, as suggested by European Parliament, adding a specific obligation regarding children, the obligation to advise the national parliament and government, the obligation to provide information to any data subject concerning the exercise of their rights, to establish and make a list in relation to the requirement for data protection impact assessment, encouraging the drawing up of codes of conduct, promoting the establishment of data protection certification mechanisms, and having a periodic review of certifications issued. Moreover, conducting the accreditation of the body, monitoring codes of conduct, authorizing contractual clauses, and fulfilling any other tasks that would be related to the protection of personal data. In its final draft, Article 52 takes on board most of the proposals from European Parliament and EU Council and provides a long list of tasks that should be carried out by supervisory authorities, without prejudice to other tasks set under this regulation. Those would be monitoring and enforcing the application of the regulation, promoting public awareness and understanding of the risk, rules, safeguards and rights, with a special mention on children, advising national parliament, government and other institutions and bodies on legislative and administrative measures to be taken, promoting the awareness of controller and processor of their obligation under this regulation, upon request providing information to any data subject, dealing with complaints and investigating and informing the complainant, in particular if further investigation or coordination with another supervisory authority is necessary, cooperating with other supervisory authorities, conducting investigations on the application of the GDPR, monitoring relevant developments such as, for instance, a great evolution in the frame of information and communication technologies or commercial practices, adopting standard contractual clauses nationally, establishing and maintaining a list of the requirement for data protection impact assessment, giving advice, encouraging the drawing up of codes of conduct and giving an opinion and approving such codes, encouraging the establishment of data protection certification mechanisms, seals and marks, carrying out a periodic review of those certifications, drafting and publishing the criteria for accreditation of a body in the frame of the code of conduct and of certification, conducting such an accreditation, authorizing contractual clauses that would be called as ad hoc clauses, and approving binding corporate rules, contributing to the EDPB work, keeping internal records of breaches, and fulfilling any of the tasks that would be related to the protection of personal data. Overall, each supervisory authority shall facilitate the submission of complaints by measures such as a complaint submission form and making it available electronically. The performance of the tasks of the DPA should be free of charge for the data subject and for the data protection officer, if any. Where requests would be manifestly unfounded or excessive, the supervisory authority may charge a reasonable fee. A key recital in GDPR is recital 100, stating that the supervisory authority should have in each member state the same tasks and effective powers regarding investigation, corrective powers, sanctions, authorization, and advisory powers. It also stresses that the measures taken by the supervisory authority concerned should be appropriate, necessary, and proportionate. That is to say, taking into account the right of every person to be heard before any individual measure would be taken and affect him or her, in order to avoid superfluous costs and excessive inconveniences for the persons concerned, meaning data subjects, of course, but also controllers and processors. Each legally binding measure should be in writing, be clear and unambiguous, and it may give rise to judicial review. Currently, Article 28 of the directive lays down that each member state shall provide that the supervisory authorities are consulted when drawing up administrative measures or regulations, and that, among other tasks, each supervisory authority shall hear claims, and the person concerned will be informed of the outcome of the claim. Drawing up a report on the supervisory activities at regular intervals is also part of the tasks of the DPAs. What should accountable data controllers and processors get prepared for? First, they will have to be aware of their obligations under the General Data Protection Regulation and understand the risks, rules, safeguards, and rights in relation to the processing of personal data as promoted by each supervisory authority, specifically when addressed to children. They will also have to be aware that cooperation between supervisory authority means sharing information and providing mutual assistance with a view of ensuring consistency in application and enforcement of the GDPR. Each supervisory authority will maintain a list on requirements for data protection impact assessments that might be useful. Controllers and processors will also have to use new compliance tools such as codes of conduct, certification, or national standard contractual clauses as provided by DPAs. Each supervisory authority will facilitate the submission of complaints using submission forms which can be completed also electronically, and this is something that will be key regarding the investigative powers of supervisory authorities. Controllers and processors shall finally bear in mind that each measure from a data protection authority should be appropriate, necessary, and proportionate, respecting the right of every person to be heard before any individual measure which would affect him or her adversely is taken, and avoid superfluous costs and excessive inconvenience. That is to say that each legally binding measure from a data protection authority should be in writing, clear, and unambiguous. Key question now will be to know more about the consistent implementation of the different tasks identified by the GDPR by each national data protection authority.